Is a record kept if my child is not found to be abused or neglected? Possibly. Some states have policies that allow them to keep all reports on the registry. But federal law says that you should not be listed in any place accessible to the general public or to people who do employment or background checks. The Child Welfare Agency itself, however, can maintain this information for its own future uses unless your state laws do not allow such records to be kept. If you find that your name has been wrongfully listed, you have the right to appeal to have your name removed. Ask your lawyer or agency worker if your name will appear in the registry. If your name does appear, how long it will be there. A potential employer can learn of your involvement with child protective services. As a parent, are my rights affected or changed during an investigation? During an investigation, there is no legal status change, as a parent. Unless there is an emergency removal of your child from your care, you will keep all of your rights as a parent. When my child is interviewed during investigation, can I be present? The CPS worker has the authority to talk to your child and to your child's brothers and sisters without your consent and outside of your presence. If the report claims that you or someone else responsible for your child's care has hurt your child, the law allows your child to tell what has happened without the family members present. Therefore, the CPS worker decides who should be present during the interview. Although your child can be interviewed and physically examined without your permission, your cooperation and permission may be requested. Must I allow CPS worker into my home? No, you do not have to let a CPS worker into your home or answer their questions. Despite this, the CPS worker is still legally required to investigate reports of suspected child abuse and neglect. If there is reason to believe that your child is in danger and you deny access to your home and your child, the police may obtain a search warrant to enter your home and check on your child. If my child is removed from my home during a CPS investigation, will there be a court hearing? Yes, CPS agency must file a neglect or abuse petition with the court that handles juvenile or family court matters, requesting a preliminary or emergency protection order. This order gives the CPS agency temporary custody. This custody allows the agency to protect your child's life, health, or general care until a hearing about the emergency placement can be held. An initial hearing, often called the emergency removal hearing, is held within a short time. Actual number of days depends on local laws. This hearing determines whether the emergency protection order was justified, and whether there is a continuing need to have your child placed out of the home. When children and families become involved with the child welfare system, they usually become involved with the court system also. Certain legal decisions about children must be made in a court. These decisions are binding. Courts generally believe that families can correct or improve the situations that brought them to the attention of the court. Can you tell me about the initial hearing? Child Protective Services describes the initial hearing, sometimes called an emergency removal hearing, that you participated in before, or immediately after your child was placed in foster care. If your child has remained in foster care after this first hearing, you will be involved in a number of additional hearings. Will I be represented by a lawyer during this initial hearing? It depends. If you cannot afford a lawyer, you can request that one be appointed. Some states may appoint a lawyer for you, but that is not always the case. Be sure to let the agency worker and your lawyer know about the progress you are making in the services you are receiving. For example, if you receive mental health or substance abuse treatment, tell them how you are doing. Sometimes there are waiting lists for services that you may need, for example mental health services, public housing, and substance abuse treatment. Some states and communities have agreements that allow families whose children are in foster care to move up on these waiting lists. Ask if you can be moved up on the waiting lists. If you have not received the services listed in your service plan, let the agency, your lawyer, and the court know this. This will make a difference as to whether the agency pursues termination of your parental rights. If you have problems and need mental health or substance abuse treatment, the decision to participate in treatment is yours alone. But be aware that if you don't get treatment, it will probably affect whether your child can return home. There is no law to force you to take your child back home. You have to want to do it, make the decision yourself, and do what is necessary to get your child back. But you have to make this decision quickly because new laws give you a limited amount of time to show that you are ready for your child to return home. You need a support system around yourself to help you get through the tough times. Take care of yourself so you can be there for your children.